Hello, good evening, welcome to Upfront. My name is Raymond Alqua. Now, more pressure is mounting on the government of the Republic of Ghana concerning the Gregory Afoko case. I'm sure by now you would know that the gentleman on the 14th of March this year was granted bail by the High Court, and some 500,000 and some bail bonds were told were later met. But since then, the man has still been in BNI custody first, we're told police custody, and various other places that made people question what the human rights record of this government has been in connection with this particular matter. In the last 48 hours, we do know for sure that the man was put before another court and bail denied him in a first trial that began today. Already, he has pleaded not guilty, together with another gentleman who have been held for the murder of the Upper East Regional Chairman of the NPP, Adams Mahama, way back in 2015. It is this human rights record that we will seek to put in proper perspective on the show today. Some people, distinguished lawyers and Ghanaian statesmen who have fought for the same human rights in times past will be my guest on the phone pretty soon. But here in studio, we'll be heading to the Parliamentary's Constitutional Legal Committee to tell us exactly what they want to say or they have to say about this particular situation going forward. Liberty denied in a democracy? That's the question we're asking on our front today. After the break, I'll be heading to the phone lines to speak to John Indebugui. Then later on, member of Council of State, Sam Okujetu, will be joining me. You will come back to our front. My name is Raymond Alqua. My guest in studio is the ranking member on the Constitutional, Parliamentary and Legal Affairs Committee of the Parliament of the Republic of Ghana. What you must know is that these are his last days in the Parliament of the Republic of Ghana too. Pretty soon, he will no longer be contesting for that particular position. The Honorable Inusah Fuseini, I hope you are doing well this day.
I'm fine.
So why are you abandoning the house? I mean, you've not been there as long as the likes of Haruna Ijusu. What is pushing you out of this wonderful, prestigious position?
Well, thank you so very much, Raymond. I think that, yes, I've not been there like Haruna so many others. But I think that 14 years is enough for me as a member of parliament, elected to serve my people. And so I think that this is the appropriate time for me to make room for a new face to emerge in the Tamil Central.
Is it that you've been incapable or you've been underperforming as a representative of the people?
Well, I have said that any opportunity I get, I express my sincere gratitude to the people of Tamil Central.
Yeah, but I'm talking about how you perform, not your gratitude.
For giving me an opportunity to actualize myself on a national level. And Raymond, the fact that I'm not the only lawyer in town. I have not been the only person who has been a member of the Constitutional Legal Affairs Committee. But I can't count the number of times you've invited me to sit here.
You're of the considered opinion that that is how best you are serving your people in the constituency.
That's a recognition of how you think that I'm serving.
Yeah, but I'm not part of the people who are determining your status in the constituency.
Well, you're not part, but you're part of the people who assess me from afar.
Okay, let's talk about Gregory Afoko. We'll come back to this matter in the nearest future. Now, I had to head to the phone lines and get to speak to one person who's in times past been, of course, fighting for the freedoms and the rights of the people in this particular country. But let me get to understand this issue from your perspective, Honorable. First, he was given bail. And of course, we know the history of this matter. It ranges back to the fact that he is related to the NPP chairman. And there was some fracas between the NPP chairman at the time and also the man who died. He was arrested after the incident happened. The man was doused with the acid, yeah. And he ended up dying in the hospital and all of the things that followed after that. That was 2015. In 2016, his two trials, 14 people were caught in that particular case. I happen to have covered the case for some time because, the people were brought from Boga to Accra for the case to be tried in Accra. They said some security reasons were responsible for that. Yep. The case started in Justice Elemensa's court, and it was an interesting beginning to know jury selection and all of that. Along the line, the state filed nolle prosequi. Then the court said, okay, I can grant him bail for him to actually go about his life. 500,000 was given. Fast forward to the time that he was granted bail in March 2019. As of the last 2 days, he was still in BNI custody, as we've been made to believe. And again, he was taken to another court with another gentleman who was later on arrested, who was being looked for, actually was on the Interpol's wanted list. And he's been actually arrested, and the two are now beginning their trial. There are many people, one, the Ghana Bar Association this morning spoke to it, said this is unfair to the gentleman, his rights are being abused. Occupy Ghana has also said the same thing. There are several other well-meaning Ghanaians that are of the opinion that this is not how a democratic country should be treating one of its own. The question that has been asked is whether or not the death of Adams Mahama is less important compared to the freedoms or the rights that are being restrained in the case of the gentleman Gregory Afoko.
Well, thank you so very much, Raymond. In the pursuit of justice for the family of Adams Mahama, one should not compromise the fundamental human rights of others. And that these are two separate things. Now, you must also understand that Gregory Afoko was arrested on circumstantial evidence. No one caught him directly pouring acid.
Oh, yeah.
So it's circumstantial evidence. And so now the case was so grievous that at the beginning when he was arrested, everybody thought that, well, let's grant the opportunity for the courts to go into the matter and determine whether or not he was culpable, responsible for the commission of the offense. Along the line, and this is what is more interesting in this matter, along the line, the court came to the conclusion that either there was unfair delay, undue delay in the prosecution of the case, or that they had come to a point that they thought that Afoko should be given temporary respite to be able to carry on with his life while still attending trial.
I'll not unduly interrupt in this one, but give me a second, let me go to the phone lines. Let me speak to senior lawyer John Indebugri there. You're welcome, sir. And I would, okay, so before I speak to Mr. Indebugri, let me first and foremost go to Council of State member and also former Bar Association president, the Honorable Sam Okujeto. You're welcome to Upfront. I hope you are doing well this evening.
Oh, yes, I'm doing well, thank you.
Now, there's a big question that's been asked in this particular case, in the handling of this matter. The big question is whether the limitation of the freedoms of Mr. Gregory Afoko is paramount or more important than the overarching matter to do with whether or not Adams Mahama and his family deserves justice. Should this question even arise in the first place?
Well, I know that the tragedy in our society is the fact that we are all experts. And so when something crops up, you find out that a lot of voices are being raised who do not even understand the intricacies of the legal process. And therefore, we distort the matter, and then we raise it into a political level where partisan politics comes in. And so people begin to take stands. And then when it happens like that, the actual crime which has been committed is completely ignored. And so the issue is that as a family, whose son, whose father, whose relative has been murdered under some bizarre circumstances. Who were the culprits? The allegation was that there were two people. One was arrested, the other one couldn't be found. Now the information we have is that the second person has been found. So they have to re-charge the two of them now. They can't go on the old charge against one individual. This is my understanding. But it looks like now it's been so hyped that nobody is talking about the man who has been killed. The issue now is about the one who is being accused. So even though I am a human rights person and I'm so much concerned about the freedom of the individual, I think we should be cautious in a society the way we handle matters of this nature.
But certainly, the two can be separated and dealt with, can't they? Because we know that as of March 14th this year, the Court of the Republic had granted bail to the man. He stayed in jail.
The who? The Republic or the court?
The court. The court
yes,
had actually
it's
granted.
Not the Republic. You don't use words like that, Republic again. Use the court.
Okay, the court had actually granted bail.
Because you confuse the ordinary person.
Well, I'll only say the courts of this republic, but anyway.
No. Don't use republic.
I get you.
Court.
Now, the court had granted bail to the gentleman.
Yes.
And he had actually stayed in the BNI custody since that time till the last 2 days when he was put before court again. Certainly, yes, you would admit there was something wrong with that.
Look, the court system works. There are lawyers that he has hired. They know the process. They know that if a judge gives a decision, you don't agree with it, you appeal. It's not a matter for the media to take a decision upon that. You don't decide for the judges.
But this judge has actually decided. The
I said,
previous judge has decided
whatever
clearly.
complaint there is, there are judicial process. You say a judge has decided. Another judge has also decided. Is that not correct?
No, but
is that not also the court system?
Yes, of course. I mean, we are talking about the time that the man had to stay in the custody of the BNI.
No, you're not getting the picture. What I'm saying that whatever time it is a matter for the judge to decide. It's not for you and I.
So that's how you think remedy can be sought in this case?
That is the way the society has been structured. In every society, legal matters are decided by the court, not by the media, not by me, not by anybody else. I can have my opinion. I could even disagree with the judge. But nevertheless, it is a court that has been authorized by law to deal with the matter.
So how does a man who was actually asked to be on bail stay in BNI custody for more than 3 months?
I am saying that whatever it is, the court is there. Let them go to the court and challenge it.
Okay, so that's what you think that his lawyers should do, right?
Yes, exactly. That is what his lawyers should do.
Now,
it's not for you or me to decide.
I get your point. Now, some have said that this is a blot on the human rights record of this government.
No, that is a matter again for the court. You see, when you are talking about human rights, the family of the man who has been killed, they also have human rights. We always put the matter aside. I was telling Raymond this morning that what I noticed is that, for example, in the Woyome issue, we know the way the matter was being run. And that in the end, the actual offense has become irrelevant. It was no longer even being discussed at all. And so we only talk about the human rights. But there are other people, human rights, also involved in the subject matter.
Now, the question I'm actually asking is, people believe that this is a blot on the human rights of the government of the day. I am saying that
it is not the people who decide what is the blot or what is not a blot. If there is a problem, the judicial process is been set up. The judges are there to decide. And if there is a violation, the higher courts are also there. That's why normally, you have a magistrate court, you have a circuit court, you have high court, and then you have appeal court, which has 3 judges. Then you have Supreme Court, which can be either 5 or even 7. The processes are all being laid out.
I get your point. Now, this is outside the court. The issues being raised are outside the court. The people who are concerned...
It cannot be outside the court. So long as the person is being tried in the court has seized with the matter.
Okay. Now, to those who say that the continual stay of the gentleman, even when he was granted bail, prior to the case going back to court, was an affront to the human rights record of government of the Republic of Ghana.
This is what I'm saying, that you people, when you do that, you are trying to say you want some politician, because he's a president, he should go and interfere in a process which does not concern him. This is why I'm saying that avoid languages like that.
I see.
Because we use languages like that, then we take the matter completely out of context. Then it becomes a political ball game now. For some people trying to score. Don't use words like that.
Now, the
courts are the only ones seized with the process of that deciding on issues of judicial matter, not any outsider. The president cannot tell the court what to do. Neither can even the Chief Justice herself tell even the judge what to do. It is not allowed.
Okay. Now, the concern in this case was that the judge had decided, that the other judge had decided clearly.
A judge had decided.
Yes, a judge had decided clearly that the man should be given bail.
Yes.
The delay and continual stay of the gentleman in BNI custody had nothing to do with the judge. It had everything to do with the people at the office of the BNI who insisted on keeping him there.
But I understand from what I have read that they've gone to another court who has now rescinded the bail. Or you're forgetting that one, or did you read that?
I get you. That's a more recent decision. That's like 48 hours ago.
In the court, the people, the lawyers, if they have any problem, that was why they should have raised it.
I see. I get your point.
That's the forum they should have raised it.
I get your point.
Yeah.
But the concern of many is about why the gentleman had to be in the custody of the BNI even when he had been granted bail.
I am saying that you are taking the matter completely out of context. That you are trying to take a political decision upon a matter which is a legal matter. That's what I'm saying, that you, the media people, should be cautious the way sometimes you take issues, because sometimes you are doing a fantastic job, but sometimes you completely misconstrue the process.
I see.
And then you give it a completely political nature. And then you allow others who are ignorant of the legal process to jump into it. Then it's like public opinion must decide this way or the other way. Public opinion does not decide matters of legal matters.
Distinguished counsel, the body that you previously heard, the Ghana Bar Association, Occupy Ghana, led by lawyers in this particular case, have all said that the detention of the gentleman previously was an act against his human rights, which could
Why
not be
don't they
condoned.
go to the court and challenge that violation of human rights? What is preventing them?
You disagree with them?
No, what I'm saying that what is preventing them from going to court to challenge the violation of human rights that they are alleging?
You don't think that they had every right to do so?
No, I'm saying that they have every right to do that. They should go to the court.
I see.
It's not the media that decides.
I get your point. I mean,
Yeah, what I'm saying is that what has been happening in Ghana is now that we have media trials.
I see.
The media is being used as a forum for trial of issues which are legal. And I'm saying that it is not the correct approach.
I would be privileged, and thank you so much for joining us today.
Pleasure is mine.
Yes, sir. Sam Okujeto is a member of the Council of States. He's actually a former Ghana Bar Association president. Now, let me stay with the Bar Association because one of its members is also on the phone line. The Honorable John in Debugri. He was a PNDC secretary. He's actually been a member of parliament too in times past, if I do recall properly. And welcome, sir, to Upfront.
Thank you, Raymond.
I hope you are doing well this day.
Well, yes, I'm trying. I'm managing.
The thoughts of more likely Sam Okujeto is that this is a matter that plays out in court and court only, and if people feel their human rights have been trampled upon, that's where the argument should be made. Indeed, the Ghana Bar Association this morning was a bit worried about what happened in the Gregory Afoko case. To you, do you see anything wrong with the man being granted bail and yet being kept in BNI custody for more than 3 months?
You see, I want to agree with senior man, Sam Okujeto, my very good friend. Good evening.
Good evening.
Chief. And I want to agree with him to some extent. And to say straight away that there's been a lot of muddling issues. And I presume that the purpose of this discussion is to educate the public about the legal implications of what has been happening and what has not been happening. I don't have much information. I'm just getting information from the various media outlets. So I'm going to speak on that basis. Now, I start by saying that I don't need to call anybody by name. I don't need to call Gregory Afoko. I just start by saying that a person is alleged to have committed murder. He is arrested. A murder case is triable by the High Court. But the murder case is not taken straight to the High Court. The accused person will be taken before a district magistrate for what we call committal proceedings. The district court has no jurisdiction to try a murder case. And therefore, the district court cannot grant a person accused of murder bail. But while the accused person is before the district court going through committal proceedings, he or somebody can apply to the High Court on his behalf for him to be admitted to bail. Now, the High Court may be minded let's take it that the High Court is minded to grant bail and has granted the person bail. Even if the person is let out as a result of the grant of that bail, the committal proceedings will continue and will be completed. If at the end of the committal proceedings, a prima facie case, or there's some evidence, there is some evidence worth putting before the High Court, the accused person will be committed to be tried at the High Court. If there is, the evidence is so porous that, in fact, there is no the possibility or the probability of the accused person being found guilty is very low, the district court may discharge the accused person. Let's take it that the accused person is indicted or is committed for trial at the High Court, because this is the situation we are facing. When the accused person has been committed for trial at the High Court, everything that happened at the district court is wiped out. I mean, if he was on bail, the bail is no more operational.
I see.
Because the court, the trial court, the court before which the accused person who has been committed is now to stand his trial, has a choice either to grant or to refuse the accused person bail, notwithstanding that the person was on bail before he was committed for trial at the trial High Court. So the problem in Afoko's case may have arisen because the media started saying that one High Court gave bail and another High Court has rescinded the bail. I don't think that that is the scenario. I think that the scenario is that it is further confused by the fact that Afoko was standing trial for a very long time, almost up towards the conclusion of the case, when the Attorney General entered nolle prosequi. When the Attorney General entered nolle prosequi and Afoko was discharged, everything that had happened under that trial was wiped out. So the whole thing was starting afresh. Afoko is taken to have been arrested afresh together with his Alangdi or somebody. And now they were to go through the committal proceedings again. I don't know whether they adopted the former committal proceedings. I would find it difficult to presume that, because Alangdi did not go through committal proceedings. So they may have had to go through another committal proceeding. And then during that period, an application was made to the High Court. He was granted bail. The question is whether the bail conditions were satisfied. But I will come back to that. There was an application under the second trial for bail, and the court was minded to grant bail and did grant bail. Now the question is, did the second court, that is the trial court now, is it true to say that that court has rescinded the bail that was granted by the first High Court? In my opinion, no. If it was during committal proceedings, after he has been committed, those proceedings are no more, processes that took place during those proceedings are no more valid. And therefore, the proper trial High Court has an option to grant or to refuse to grant bail.
I get your point.
And I think that is what happened.
I get your point.
Now, let's come to the question of why bail was granted. And he was, I think, in March or so.
Yes, in March 14.
And he has been held up all the way up to today.
Yeah.
The question is whether the bail conditions were satisfied.
At least according to the lawyers, this was the case.
Yes, I don't want to presume that the lawyers are, I don't want to, they are my learned friends and I want to take every lawyer for his word. But there are certain technicalities involved that if the public is not made aware of, we may just go and muddy things further, as Uncle Sam was trying to say.
Okay.
Now, look, Afoko is ordinarily resident in the Upper East region, either in Sandima or Bolgatanga. Now, the bill, as I told you at the beginning, I'm just piecing things together. The bill granted, according to what has come to my attention, was the conditions were that he should furnish 2 stories.
Yeah.
One to be justified. One to be justified means one of the storages must have landed property, and that property must be properly registered with the Land Commission Secretariat. And that land must be land that is accessible by the port.
Okay.
Now, please, let me finish. Don't be in a hurry.
Oh, no. Yes, please proceed.
Yes. Now, when the court has pronounced that bail granted and not the case, it throws the file away and it has finished the job. The rest of the process is administrative. It is between the investigating officer and the registrar of the court. The officer investigating the case and the registrar of the court. Sometimes they go back to the judge for getting clarification. But in terms of the judicial process, he has finished his work. Now, the investigator, in a case where there is justification, can insist that the property must be located where he can easily inspect it. So, and he can insist that because Afoko is ordinarily resident in Bolgatanga or Sandima, the property must be located there. It can be that the Afoko is unable to get property in either Sandima or Bolgatanga or anywhere in the Upper East region to the value of the bail sum. And therefore, that can be a problem.
I see.
I don't know whether all these things were satisfied.
Okay.
But if all these things were satisfied, the justification was done, and Afoko was still kept in custody up to now, then the problem is between the investigating officer and the registrar. They are the ones who will complete the documentation and then let the gentleman out. And so I want to agree with Sam that sometimes the media, in your enthusiasm to project human rights and so on, may report issues in such a way that confusion may arise. And I suspect that that is what may happen.
The only problem is that it's not only the media that's been raising this matter. The Ghana Bar Association that you are a member of, the other group in Occupy Ghana, that's actually been led by lawyers, and lawyers issued the statements on their behalf, all believe that there was everything wrong with continual detention of the gentleman, and that they are convinced that the bail bond was met, and every other issue that ought to be determined was actually determined in this particular case. They certainly cannot be like the media in this case.
Yes, so I'm not saying that I'm not blaming the media. But you see, the first thing that was put out was that the bail bond, the bail that has been granted for Jugora Popa has been rescinded. That's not true. The bail wasn't rescinded. The bail was wiped out by what we call a function of time or by circumstances. The bail was no more existent at the time he appeared before the Second High Court.
I get your point.
So it is for the media to have by putting out that one High Court granted bail and another court has rescinded, created a problem. And I don't want to. I've told you at the beginning that I don't have all the facts.
I get you.
I hope that the Bar Association, our executives, have gone and made sure that the bail conditions were really satisfied. And if the bail conditions were satisfied and the officers I have mentioned refuse to let Afoko out, it becomes a matter of contempt. That is what Uncle Sam is saying. It has nothing to, it is not about issuing statements.
Okay.
With the greatest respect. It is a matter, a judicial matter. They should go and file contempt proceedings against those persons who disobeyed the court order.
And in this case, that's the investigator and the registrar.
And the registrar of the court. The court that granted the bail.
I see.
And it will lie between them. It's somewhere between them. Either the registrar was being recalcitrant or the investigator, or both. So if you go for contempt proceedings, the one who is guilty will come out and you'll be punished.
I'm pleased.
And the matter comes to an end. So I agree with some that we unduly act outside the judicial process in our enthusiasm to promote human rights and so on. And in the process, we throw the baby away with the bathwater.
I'm privileged to have had you join us with comments today. Thank you so much, sir. And you heard there, Johnny Debugui is also a senior lawyer. Let me come back into the studios. And one man that would now be putting on his wig consistently is the Honorable Member of Parliament that I've unduly kept here in the studio. The Honorable, you're welcome back once again.
Thank you.
So I needed these perspectives because they are the ones that have actually consistently fought for human rights on these matters. I wanted to put it in the era of course, not only during these times, also during military eras and all of that. So you've heard from Sam Okudzeto on this matter. You've also heard from Johnny Debugui on this matter. You've heard from the Ghana Bar Association that's saying that the man has been wronged and that's very unfair to him. And also Occupy Ghana that has very tough words for what happened to Gregory Afoko. Do you think that this is all a creation of the media in seeking to uphold or to some extent be needlessly interested in some form of human rights abuse where none might not exist in this case?
Well, Raymond, I was surprised to hear the member of the Council of State, Sam Okudzeto, blame the media for hyping the case of Gregory Afoko, and also shocked by the collaboration of Ndebore. What is the work of the media? The media simply reports what happened. And so if they report what happens, they hype it. They follow stories in which the public has an interest. Mm-hmm. If the media publishes a story in which the public has no interest, don't publish it again. Mm. That is what the media is driven by the market. Yeah. And so I simply fail to see how the media has hyped this story. It's precisely because of the interest that the public has in it. That's why the media is talking about it. Yeah. That's why we are here. That's why his son was called. That's why Ndebore was called. Mm-hmm. Now, the second thing is, at what point can we compromise the fundamental rights of persons?
He says that the rights of the family and Adams Mahama,
the rights
should not be overcrowded.
There are two different rights. There are two different sets of rights. Mm-hmm. With the greatest respect to Sam Okudzeto, there are two different sets of rights. Bam Adams was murdered through this an acid attack. Yeah. Okay? The perpetrators ought to be punished. They ought to be identified and punished. The interest of the family of Mahama Adams is to seek justice. Yeah. Okay? That's justice. And seeking justice is part of their rights in this matter. Mm-hmm. The interest of Afoko, who was arrested by virtue of circumstantial evidence, is to have a fair trial and the respect of his fundamental rights until the court is able to connect Afoko to the crime. he at all material times ought to be presumed as an innocent person. So when I heard Sam Okujato, member of the Council of State, one time president of the Bar Association, espouse the views that he espoused on this platform, I cringed. What he's suggesting is that the interest of the deceased can surpass the interest of an accused person in a criminal trial. I fail to accept that. There are two different sets of rights, and there must be a balance. Two, the Honorable Ndebogre says he gives the procedure, and that's the procedure.
Yeah.
So at the point that the state enters a nulli prosequi in a criminal proceeding, what happens in court? The accused person ought to be discharged. The accused person can no longer be held because the state is saying that I am no longer interested in prosecuting this matter.
Yeah.
Now, but it is sometimes a strategy of the prosecution to enter a nulli prosequi to bring either fresh charges or to be able to pursue the prosecution holistically.
And in times past, they have rearrested the person on these fresh charges.
Well, if it's a strategy to continue, they immediately rearrest that person. When that person is rearrested, his rights under the Constitution kick in. He cannot be detained beyond the allowable period of time
48 hours in
that the Constitution grants. So within the 48 hours, if he's brought to court and the court is minded to grant bail, then he satisfies the bail conditions. On what grounds will the prosecution be holding him? On what grounds? If the bail conditions have been satisfied. This is what the Bar Association is drawing attention to. And the position of the Bar Association is consistent with the Kwibo case.
Yeah, he said so himself.
Yes, where he went to court and said every offense committed under the sun is bailable until the court thinks otherwise. Okay? Now, so if the court granted bail and Afoko satisfied the bail conditions and he was not processed, then there is a problem. There's an abuse of his fundamental rights.
And this is being since March.
Now, again, what I've heard from media men who were in court is that the first time Afoko was brought in to court under a new judge, probably for the commencement of the trial of the case, the Attorney General's office stood up in court and prayed for the rescission of the bail. Now, if Ndebogre is saying that it was because of the committal proceedings and the delay in getting the accused person tried in court, that was why the court granted Gregory Afoko bail. And when the trial was about to begin, and the prosecution thought that Afoko constituted a flight risk, the ought in pressing fresh charges have drawn the attention of the court to the fact that the beginning of this process wipes out the process that was begun in the previous case.
That's interesting.
But why do you pray for bail? I mean, for the rescission of the bail. Praying for the rescission of the bail is a technical, it's an acceptance of the prevailing conditions that Afoko was admitted to bail. And that now that the trial is beginning, we want to rescind the bail. Now, that goes to confirm what human rights activists are saying, that they deliberately, consciously decided not to effectuate the bail on Afoko, so as to give them the opportunity to be able to pay the court at the time that was due for a rescission. And that period between which he was granted bail and the period which they paid for the rescission of the bail constitutes a violation of the fundamental rights of Afoko.
You also believe so?
I also believe so. And I believe so because it could happen to anybody. I believe so because of the circumstances of the arrest of Afoko. I have tremendous sympathy for the family of Mama Adams. Nobody should be allowed to go through those pains. I mean, the family of Mama Adam ought not to have been allowed to go through those pains that they went through. Mama Adam himself ought not to have suffered that treatment just because of politics. So clearly, we sympathize with the family, but we have a duty, an abiding duty, to always uphold the fundamental rights.
The state is,
even if a person
is powerful.
If a person is convicted for murder and he's to be hanged,
he still has some human rights.
He's even granted a last wish.
Now the state is powerful. I've heard, and you heard Johnny Debugri say there, that the investigator and the registrar who are supposed to give effect to the bail in this case ought to be held responsible for it. And they could be cited for contempt in this particular case. So can that remedy the situation?
It cannot remedy the situation.
It cannot.
It's gone. It's gone by the affliction of time.
Yeah.
What will it serve? What purpose? It's not moot.
Because, I mean, a new court has actually given
it's not moot.
Yeah.
But what is interesting in John Deborah's submission is that if he indeed, and he believes that if the conditions were met and the prosecution and the registrar failed, refused, or neglected to admit Afoko to bail, and so they might be liable in contempt, that is an admission of the violation of the rights,
human rights
of Afoko.
Can you in Parliament step in? Can you ask the people who are supposed to protect his human rights to account for that? Can you call in, let's say, the Attorney General and ask, why are you as leader of the bar in this particular case? Why did you allow this to happen? Or you can't do
Well,
so?
that will be an ex facto rationalization of what has already happened because it is gone. I mean, if Afoko had petitioned Parliament at the time, or if the attention of the Constitutional, Legal and Parliamentary Affairs Committee was raised, was brought.
But you are aware of this as far back as March this year.
I was aware that Afoko was undergoing trial. I was never aware that he had been granted bail. And none of that was brought to the attention of the committee. Now, if it had come to the committee as a petition directed at the Speaker, which would have stated a referral to our committee would have recommended otherwise. And probably the Attorney General would have been invited to explain the situation to
why that is the case in this particular case. No,
exactly.
But currently, are there no remedies available to him?
What remedies?
That he was unduly detained for a period of time. He cannot seek any remedies in that direction.
How are you going to compensate him? Probably officers.
He can be given money for it, actually.
No.
No, it's not possible.
It's not possible. Officers who the officers will now have explanation to give.
Yes.
And if the court, if an investigative body is constituted to look into the matter, come to the conclusion that the officers failed to act consistent with the law, they can be sanctioned.
Okay.
Okay, but Afoko, what rights?
There are no rights or remedies available to him currently. Now, I want us to, because we are racing against time now, look to one other issue that Parliament has been up to under the very circumstances that we're dealing with. What's the status of the vigilante bill? Passed?
Well, we passed the vigilante bill.
Are all the thorny issues dealt with now?
Yes, almost all of them. And we actually improved on the vigilante bill because what happened was that, you recall, I had said that the bill lacks conceptual clarity in many details. And so what we did was to work on exactly what government was intended to do with vigilantism. And this was made manifest when we invited the stakeholders. The Attorney General was in attendance herself, and threw some light on what government was intended to do. That guided us in looking at the provisions and ensuring that we identified the problem and dealt with it.
But you passed a vigilante bill. We already had Ayasu West Work on Commission also sitting, and he has a report that is being studied by the government of the Republic of Ghana. Can we, and people have actually complained about we having more laws and yet we're unable to implement them. Can we implement the vigilantism bill in this current state? Of course, has it been assented to yet?
No. It's waiting for an assent from the president.
Okay,
but I'm looking for the day that the president will assent it, because every day in the history of this country politically, we hear vigilantes attacking. And just in the recently ended voter registration
exercise,
we read about many attacks by vigilante groups. So it's important that the government assents, and we'll see the commitment. We'll be able to assess and measure the commitment of government towards dealing with vigilantism.
That's how best we can do that.
That's how best we can, because we passed the bill. I mean, government said, look, the legal regime, the criminal code did not provide for remedies for vigilantism. That was the argument, even though there was a body of people who argued vociferously that the criminal code provided, or the Criminal and Other Offences Act provided for
yes, that argument was made.
It was made. Now the president said no. I think that we need to single out vigilantism and deal with it. At all other criminal offences provided in the Criminal and Other Offences Act seem to fall short of vigilantism.
I see.
Okay, so let's deal with it as sui generis, as a new form of crime, and then provide for sanctions. And we've done that. Now it's with the problem on its way to the presidency for the assent of the president. And the only way that we can demonstrate our commitment is when we begin effecting it. Yeah,
that's the question I'm asking. I mean, will we ever have the political will, even with the law, to do with this matter?
So let's test the political will. I know vigilantism will come. I know immediately he assents that probably the next day we'll have to deal with vigilantism and we'll test the result of
That's interesting to know that. Now, there's a question to the minds of many who really were not privy to the details of this bill. Let's be clear. What is the bill seeking? What is the object of this bill? What is it seeking to stop? What is it seeking to prohibit? Which gray areas in the law is it seeking to clear up?
It's seeking to clear, first of all, it's a balance between the right to form an association and the need to conform with the laws of the state.
I see.
So it's seeking to criminalize acts of individuals within a group or by themselves intended to threaten or intimidate or cause violence to other persons for either in support of a political party, chieftaincy, religion, illegal mining, and all those things.
I get you. How about land guards?
Yes,
because it was raised previously that land guards were supposed to be part of the
land guards are apart. So land guards, now anybody who uses land guards for the purposes of protecting property, which land guards in guarding the land commits or uses violence or threat of violence, will be an offense under the vigilantism bill.
So the key word here is the use of violence or the threat of violence in this case.
Or
the mere presence of people doesn't amount to anything.
Unless that
mere presence of heavily built men, macho men,
unless their presence evoke some threat to the threats of violence.
And of course, unless that is what they call it, then we cannot say that it is actually supposed to be an issue now.
Yeah, it's not an issue. It won't be an issue if we demonstrate political will towards fighting vigilance.
There's usually a time frame for the executive to assent to a bill. If it's not done so, they have to give reasons and all of that. What time frame do we have now?
Well, the president is well within the time limited for the assent of bill or the reason of objection, and so we have to wait until
that period actually is done.
Until that period lapses. If since so far as it's within the time, it is not an issue for debate now because it's still within his time.
Now, there was a question about the number of vigilante groups already mentioned or identified. Apparently, you had extended the scope of the vigilante groups that were supposed to be in this particular one. There's a question generally about, in the future, if a body looks like purport to do the operations but with no violent connotations, would you be able to capture that too?
Yes, initially, the bill had contemplated the minister using an executive instrument to add to the list provided in the schedule. But the members of parliament filed amendments to take that executive power from the minister and invest in the minister a legislative authority.
Okay.
That is, so the minister must come by ally. Anytime that he wants to add to the list of vigilante groups in the bill, he has to come by ally.
I see. Now, that is to close to that point. So we're seeing when the actual implementation of the vigilantism bill is supposed to... Now, I'm supposed to end the conversation I actually asked you about, which you have to end with. So the issue about not going to parliament, is it because you in the future want to contest for president or something?
Oh, no. It's just that... I mean,
you are done with politics entirely?
Not politics. No, I'm done with parliament. I'm very active in politics. I will be very active in politics. I'm not done with politics. I'm too young to abandon politics.
Really?
No, I'm not done with politics. I just think that 14 years in parliament is enough. I have had the opportunity to serve my people, and I think that I should give somebody an opportunity to represent.
What was your biggest achievement in the constituency?
Well, biggest?
Yes.
Well, they rank a lot, but I was able to increase a lot of classroom space, deliver water through my own initiative and in collaboration with other NGOs. And companies. I was able to.
It's interesting that your biggest achievement is not that you help pass a law that is supposed to be right. So about
no, you said in the constituency.
Yes.
You said in the constituency.
You feel your activities.
No, you said in the constituency.
Yes.
In parliament, my biggest, what I consider the biggest, was that you remember in 2006 the domestic violence bill.
Yes.
You remember when they passed it initially? I was not in parliament when they passed it, and they had sent it to Kofor for assent, and he rejected it because of what they said was a provision in the bill which was interpreted to mean marital rape.
Yeah.
The redrafting of a bill of that provision was done by me.
Well, that's interesting to know. Well, Honorable, thank you so much, and we wish you all the best. Well, folks, that's where we end today's edition of Upfront. My name is Raymond Alqua. Thank you so much for joining us on today's edition.